Reynaldo Lopez, Nora Lopez versus Antonio Mendieta Jr. and Lisa Ross. So who do I have here on behalf of our plaintiff Lopez and Lopez? Anyone?
Yes, this is Mr. Reynaldo Lopez.
Oh, good morning. Thank you, Mr. Lopez. All right. Do I have someone here on behalf of Antonio Mendieta Jr.?
Yes, ma'am. I'm here.
Are y'all in the same camera?
I'm here too.
Oh my God.
This is Nora Lopez.
Hello. Hello,
okay.
ma'am.
Okay. Everyone's yelling. All right. I got.
Can you hear me?
Yes, I did, Miss Lopez. I can hear you.
Okay. All right. I'm the one that filed the eviction notice. My brother's a homeowner. I'm the tenant.
Mr. Mendieta,
Yes.
is the gentleman next to you? Who is that?
He's the homeowner.
That's Mr.
Where
Lopez.
do you can't see me?
Yes, ma'am. He's a homeowner, and the person speaking, Nora, she's just the tenant.
He's not
No, I am the tenant. What do you mean I'm just a tenant?
Yeah,
You're just a squatter. I'm coming out there because I don't see myself on the.
Do y'all all live in the same household? Is that why I'm getting?
Yes.
That's
We
why
do,
I'm confusing.
do you see
You see
them?
why the judge was confused because the plaintiff and the defendant are in the same camera together. That's why I was lost. Okay, now who is this person?
Okay, I don't see you.
Who is that woman, Mr. Mendieta?
that's the woman that filed the eviction,
Is
not
that
the
Ms.
not the
Lopez?
owner. That's Miss Lopez. She's the one who filed the eviction, but she's not the owner.
Can you hear me?
Yes, I can, Miss Lopez.
I don't see you.
That's because you're not using your camera. You're just using the phone. If you've got to be looking on Zoom. Oh, okay.
Ma'am, she's not.
Okay, well, I don't know how to do it.
Here's my
I
confusion.
don't know how to do it. They know how to do it. They
Miss
think they got
Lopez?
everything going on over there.
Ms. Lopez, if you just want to go stand next to your brother and see on camera, I can do the whole thing that way. You don't have to.
Okay.
But then
I don't want to be standing by them. I don't want to be out there with them.
All right, then go
I don't
back
want
in
to
the
be
house.
by them.
Go back in the house. because
Okay, I'm in the
you're
house.
close
I'm
to
in
them,
my
it
room.
starts to echo. Go, that's fine.
I'm staying away from them like I'm supposed to. They're not staying away from me like they're supposed to.
Okay.
He's already put me in jail twice. He assaulted me
Lopez?
numerous times, verbally
Ms.
assaulted
Lopez?
me. He's
Ms. Lopez, I'm afraid we've had to mute you. I want to give you some information and I want to take your information and Mr. Lopez's as well. All right. Mr. Lopez,
Yes.
let's begin with you.
Okay, ma'am.
Did you file the petition for eviction?
Did I file for it?
Correct.
No,
You did not file the petition.
no. My sister did.
Okay.
And my sister is not a tenant. She just lives in my house.
Mr. Lopez, you're the titled owner of the home
Yes.
and you did not file to evict anyone.
No.
Okay. Ms. Lopez, I'm going to unmute you now. On your phone, if you'll press *6, then I'll be able to hear you. Mr. Lopez, while we're getting your sister to unmute, does your sister have any ownership interest? Okay, are you Ms. Lopez?
All right.
Okay. Good morning, Ms. Lopez. All right.
Good morning.
Are you an owner of the property?
No, my brother is. I've been living here since 2001.
Okay, Ms.
It's my brother.
Lopez, I appreciate that. Your brother, who does own the property, says that he does not want to evict anyone.
No, the thing is that I picked up assault charges on them. Actually, he assaulted me, and I went to jail. When I got out of jail, I went to the hospital where he stomped on my toes, and they were filming it, and I pushed him out the way, and then he stomped on him again. He broke my toes. I got hospital records of me going to the hospital both the times that he tried to say I assaulted him. He bit his lip and rubbed blood on his face. And then he's been breaking into the house. He's been stealing all kinds of stuff. I mean, he just needs to go. I mean, he don't pay rent. It's been 7 months. He ain't paying a penny.
I appreciate that. Ms. Lopez.
He got his ladder over there where
Okay.
he jumps over the fence and gets in the house. And my brother lets him get away with whatever he wants to do. And that's
Sounds
not,
like you might want to move yourself, but your brother.
but
who
I
owns
don't
the
gotta move
property-
right now. I don't have to
Mr.
move
Lopez,
because this didn't start until they
Mr.
moved in.
Lopez, we're going to non-suit the case because you've told me you don't wish to proceed with an eviction. In fact, you didn't even file the lawsuit, correct?
Oh, he's saying
No.
thank you. So you're gonna continue to shoot the finger at me and call me
Case
bitch?
dismissed by the plaintiff. All
No,
parties
no,
are
no.
excused. Thank you. Have a good day.
The judge and the lawyer told me to file an eviction.
Ms. Lopez, please contact legal aid about your rights as a tenant in your brother's
Yeah,
property.
I did.
Okay.
And he's already
Your
assaulted
brother,
me. I got adult protective
Mr.
services are
Lopez,
involved.
Mr. Mendietta, you're all excused. Ms. Lopez, this case is being dismissed. The owner of the property has indicated that he did not
Case
file the
is being
petition
dismissed.
and
What are
he
you
does not
talking
want to
about?
pursue.
So he can continue to
Thank
assault
you, Your
me?
Honor.
Thank you. All parties are excused.
Thank you.
Ms. Carcos, please give me the information about why this eviction is being sought.
This is failure to pay rent. Rent is $1,597 a month. They owe $1,456 for September, the full amount for October, and the prorate amount of $1,064.66 for November, for a total of $4,117.66 in back rent through today. A 30-day notice to vacate was placed on the inside of the door on September 8th. There's no government assistance, and we're seeking back rent, court cost, and possession.
All right. Was it 30 days because it's CARES or was it just 30 days?
I don't know if it was because of it was CARES, but I just know that it is 30 days.
All right. It will qualify regardless, but I always like to kind of check. And there's no subsidy, 1597?
Correct.
All right. Good morning, Ms. Kirby. Thank you for being here.
Of course.
Ms. Carcos works for a group called Nationwide. So if you've never heard of her, you've never seen her before, that's not uncommon. She would not be the person there at the office or typically with management. She's a representative who comes though on behalf of landlords for cases like this. The information that she received that she told me today is that this case was filed for financial reasons. So no lease violations other than a finance one. She said that the flat monthly rent is $1,597. Ms. Kirby, is that the correct monthly rent?
Yes, ma'am.
Okay. And she said that there was a partial payment made in September, but a balance remaining, and then all of October, and then she's prorating for November. So she said that rent
Of
has
course.
not been paid for November, but she's not seeking, the landlord doesn't want the entire month. So Ms. Kirby, is that correct? Does rent remain unpaid since September?
Yes, ma'am.
All right. Well, Ms. Kirby, with that information, the landlord meets the burden today to win the case, but what information can I share with you? Do you have any questions? Certainly, this is your opportunity to speak to the court. We want to give it to you.
I have 2,500 of it available, but they won't take partial payment. I have lost my job due to an injury, and I'm just trying to recuperate. I have a job where I train doulas, and I'm waiting for my next workshop to come up to make my money. I usually make $2,000 a class, so I know that I can make it. I've been here for 4 years, and I just need like a little bit more time to make it. And I'm also seeking help through, I'm so sorry to look this up while I'm on the phone with you. There is, I'm talking to LSC, America's Partner for Equal Justice, and Get Help at Neighborhood Centers.com. So I'm working on it. I've come through for my kids for 8 years as a single mom, so I know I can make this and give it to them immediately as soon as I can. But I have half of it right now.
Ms. Kirby, I'll give you some information that I can share with you from the court, right? And then I'll give you I'll give you information about what I hear, what you still have is sort of this timeline in front of you, and then absolutely you can go and speak directly to your landlord and share with them what you told me today, right? I'll say that it is not at all uncommon for landlords to not accept a partial payment. I hear that commonly. Sometimes they've been told that. Certainly lawyers may advise them to say, for many reasons, it may be better to wait until the hearing is held, either get paid in full or wait until then. Now that we've had the hearing, and I am going to render a judgment for the landlord, certainly you can go back and talk to them. Sometimes I hear, and this is not legally the landlord can say, we want your money and we want you to move out. That's what the law allows, right? Now, they don't necessarily have to do that. You can certainly talk to them about it. They may give you some options to now that you have had the hearing. Also, I'll tell you that I hear, and this is anecdotal, that some of the legal aid providers or the assistance lenders can help you a little bit more now that the hearing is done and it is official. You have been evicted, right? Now you're in your appeals deadline. Just it's an anecdotal thing, but I've had tenants and landlords both say that to me, that sometimes it's a bit faster of a response. So if you have already reached out to some of those providers, let them know today, my hearing was held, they did fine for the plaintiff. Now I'm kind of in a critical time of period, okay? Ms. Kirby, you absolutely have at least 5 more days beginning tomorrow. And then that timeline might be affected by the holiday next week. So to find out specifically when you think the deadline will come to an end, I would say contact any of the legal aid providers that we highlighted or any that you're already working with. Today, the judgment is, as Ms. Carcos is asking, $4,117. The judgment amount is not the total amount that the landlord will ask you to pay, though. Today, Ms. Carcos is only asking me to award rent for 20 days of the month. If you go back to your landlord and want to resolve it, the landlord will legally be allowed to ask you for all $1,597. And then if there were late fees under the lease, that will also still be there. So an eviction in law, the court can only award actual rent. So keep that in mind. And that's true for everyone who's listening here, right? If you get a judgment today, quite likely that number will be less than the actual amount sent to you by your landlord when you move out, because that can include utilities, late fees, cleaning, any of those things. All right. That's information about why that number may be different. Ms. Kirby, if you want to appeal, or Ms. Carcos, if your client wishes to appeal, either party can, then you have 5 days. I have to determine an appeal bond because the rent's been unpaid in full since September. I would typically, what I would do here is I would double the rent. So I would put the appeal bond at $31.94. Now, Ms. Kirby, for all parties listening, if you want to appeal, but you don't have $3,194, and per what I just heard from you, you probably don't, you may qualify to appeal by an affidavit of inability. But importantly, very importantly, in order to remain living in the apartment, even while the case is going to be heard by a new court, you have to pay $1,597 in full to the court. And you have to keep paying that as rent becomes due. All right.
So
email you information with all of that. We have a basic form and we send that to all the parties when the case is over. You can use that to, again, look at what your options are and contact anyone you like, including the landlord. All right. Ms. Kirby, can I answer any questions?
I'm happy that I have it. The $1,597, I give it to the court if I want to remain in the house with the kids.
If you wish to appeal and remain in the unit, you both have to pay an appeal bond or get an affidavit for it, and then you have to pay the rent to the court. We will give you specific instructions about that if you file an appeal with court.
Okay, and it'll be in the email.
We will email that. If you checked in, we got an email. We mail it too, but to get it quicker, email will get it there for you by the end of the day. Postage will probably take you to the next week. Okay, ma'am?
Yes, ma'am. Thank you. Thank you so much.
All right. Good luck to you, Ms. Kirby.
Thank you.
Thank you for the work that you do. I just recently learned what a doula is. All right.
Oh,
All parties
thank
for that
you.
matter are excused. Thank you
I
very
just
much.
trained my 10,000th student. Thank you.
Oh, wow. All right. Our next matter will be cause 25-1563. That's Pavon Batnagar versus Melanie Lay Green and others. Who do I have here on behalf of Batnagar?
Good morning, Judge Holmes. Pavon Batnagar here.
Good morning, sir. Thank you. Do I have anyone here on behalf of Melanie Lee Green? Anyone here for Ms. Green?
We do, Your Honor. I just let her back in.
Ms. Green, if you're with us, you'll need to press *6 or otherwise unmute. Do I have someone here on behalf of Melanie Lee Green? Ms. Green, I see that I see someone who's marked in as a Melanie Green, but I don't see that you've been unmuted. So if you're on your cell phone, press *6. We've sent you a request. Again, the court is ready to hear cause 25-1563 versus Melanie Green.
Judge Holmes, so Pavon Batnagar here. So I'm requesting eviction for non-payment of rent.
No, sir, I can't start with you until I get the defendant to unmute, right? I'm going to give her a minute. We're going to go to the next case, and if she doesn't unmute, then we'll move forward. Mr. Batnagar, we're going to place you on a recall. I'm going to move to the next matter, and my clerk will still keep reaching out to Ms. Green, and if she doesn't come here in the next 2 cases, we'll move along, right? Don't step away from the camera, right? If you go away, you got to stay near, because right now what's happening is I'm going to call your name multiple times. I got 18 parties here. Please be, we're in court. All right, here she comes again. Ms. Green, can you hear me? Melanie Green, Ms. Green, press *6 on your phone to unmute. Good morning, Ms. Green. You need to unmute. You have to press *6. Or if you're on the Zoom app, you can use the mute button. Fantastic. Good. Ms. Green, do you have 2 devices? You're echoing.
Yes, I was logged in on my laptop.
Turn off the laptop then, because
Okay.
I won't be able to hear you.
Okay, is it off? Can it?
Oh, yeah, that's much better. Fantastic. All right, then. All right, Ms. Mendieta, thank you. Ms. Green, now we have both parties. Fantastic. All right. Sir, why don't you tell me, what is the reason this eviction is being sought?
So seeking eviction for non-payment of rent.
Okay.
I've not received rent for the month of October and November.
How much is the monthly rent?
1,800.
Is there any subsidy from the government?
Subsidy ran out September 30th. So October 1st onwards, there is no subsidy.
What had the subsidy been prior?
I think it was the whole amount, 1,800.
And you were paid that directly by the government on behalf of Ms. Green?
That's right.
Okay, but the subsidy came to its end, and so October and November?
That's right.
All right. Is this property under the Federal CARES Act?
No,
When did you give notice to vacate?
I gave notice to vacate on October 1st as well as October 28th. Both time it was pasted on the front of the door as well as hand delivered.
All right. Is there a written lease?
Yes,
Under the lease, what day is rent due?
the first of the month.
Okay, so why did you give her notice on the first?
Because Ms. Green had promised that she'll leave by September 30th. That was the end of the lease. And
Given her
after
a
that,
notice to vacate prior to that?
that's right. So I had communicated intent to not extend the lease on September 4th.
Okay,
Ms.
so on
Ms. Green,
September 4th, you gave a notice of non-renewal.
yes, and then Ms. Green confirmed she'll move out on 30th of September.
But she did.
That's when she did not move out, I gave notice on the 1st of October. We came to your court on the 28th of October, and you mentioned that since the notice was a little less than the 30 days, we should go and give another notice and come back. So that's what I'm doing now, Judge Holmes. So then I gave notice again on the 28th of October, and then I requested for eviction with your court after that.
All right. Good morning, Ms. Green.
Good morning.
Plaintiff says that you are a tenant with this property, that the lease on its own natural came to an end, it was not extended. And that so since the lease came to its end at the end of September, he says sort of two things, that you are both a holdover because the lease has ended, and that you have not paid for rent because you have not paid for October, November. So let me ask you a little bit of questions after questions. Is it correct that you had a lease that ended at the end of September?
Correct.
Okay. And in the original lease, was the monthly rent $1,800?
Correct.
Okay. And were you receiving assistance with the rent?
Correct.
Okay. How about for October and November? Have you paid rent for those 2 months?
No, ma'am, I have a church that's supposed to be, I guess they were backed up, so I can't get them until Monday. So yes, I was going through a church, St. Vincent de Paul.
All right. All right. Well, Ms. Green, with that information, the landlord would meet their burden for a non-payment matter. I will leave the holdover issue aside because he did not actually indicate that. Ms. Green, with that, the court would award the 2 months of rent for the defendant, or for the plaintiff rather, and we'd set an appeal bond. Can I answer any questions? I don't know if you got to hear my information to the first case about what happens with an appeal of the timeline, but I'm happy to review it with you. I'm sorry, Ms. Green, I wasn't.
I said, no, I heard you on the last case. Thank you. I'm sorry. My phone is messed up.
You're doing just fine. All right. Well, here's what I would do. For October, it's the full amount. For November, I would prorate it. It would be $1,200. So the judgment for the plaintiff will be for $3,000 plus their cost of court. On appeal, either party can appeal. I'll put that at $1,800. All right. Thank you both. Then all parties are excused. We will send that order out to each of you. Thank you. Have a good afternoon. Well, have a better day, y'all. Thank you very much.
Thank you.
You too.
And it's going to be 25-1567. Foxill Apartments doing business as Alistair Oak Hill versus Micah Joselyn and others. Who's here on behalf of Alistair Oak?
Nationwide.
Do I have someone on behalf of Micah Joselyn?
Hi, Micah's here.
Good morning. Thank you, Ms. Joselyn. All right, Ms. Carcos, why is this eviction sought?
This is failure to pay rent. Rent is $1,811 a month. She owes October and the prorated of November for a total of $3,018 in back rent through today. A 3-day notice to vacate was placed on the inside of her door on October 15th. There's no government subsidies. We're seeking back rent, court cost, and possession, and this is not a CARES Act property.
All right. Good morning, Ms. Joselyn. Thank you for being with us.
Hi.
Ms. Carcos is here on behalf of the landlord, and she's given me information indicating this is a financial situation.
Yeah.
It says that under the lease, the monthly rent is $1,811. Is that the correct flat rent?
Yes.
Okay. And she said it's been unpaid now for October and November. Is that also correct?
Yes.
All right, Ms. Joselyn, I understand that finances are tough, but with that, the landlord would win their case today. Can I give you any specific information or answer any questions about the timeline or the appeals information?
I'm curious if there's any possible way to stay. Been here for 4 years and my son attends school across the street, and overall we, are seeking more stability and fell into a rough patch via work. Things seem to be clearing up. If I'm able to pay all of that, is it possible to stay?
That's not a question the court can answer. I could say that legally, the landlord can say, no, I want your money and I want you to leave. Now,
Yeah.
but they can also legally say, yeah, we're happy to work with you, right? They have come to court and received an eviction. Whether they want to still work with you, I don't know, but you absolutely have the right and can reach out to them today, anytime in the next several days to see if a resolution can be reached. The only thing I will inform is that if no parties indicate to me that they want to set this aside, the judgment does become final after that 5 days, and the landlord has up to 60 days to seek a writ of possession and actually make you and your family move out. Okay?
Okay. So I'm sorry, could you repeat that? You said 5 days?
So you have 5 days to appeal. Okay? If you don't do anything and the landlord doesn't do anything, it becomes final. And beginning on day 6, that's when the landlord can come and get, so it's called a writ of possession. And the constable will post it on the door. And if after 24 hours you haven't moved, the landlord can legally come in and pack up you and all of your items and set it outside. They don't have to do it immediately, though. The law says they have up to 60 days to do that.
Yeah.
So next week is Thanksgiving. They may not want to come and get a writ of possession from me, even if we were open, right? They may wait until middle of December. They can theoretically wait 60 full days before they would then have to evict you again if you are still in possession.
They can do what they'd like, right? I'm just, I'm wanting to like figure out some kind of payment plan, or if I get a loan. I mean, it's to the point where clearly I haven't moved out because I don't really have anywhere to go, is the point. I'm not trying to ruffle any feathers.
You're not ruffling any feathers, but Jocelyn, I don't have any authority though. Like it's kind of 1 and 1 is 2. What I can say is now that the landlord has been proven, certainly you could go and talk to them. And
I can't combat that. I'm totally in agreement and understand the situation. So, okay.
Reach out to services though. Like I said to an earlier person, I have heard that once the case is done and you're in that 5-day window, sometimes services are available to you. Okay.
And you were speaking, I'm sorry, real quick. You said on the precinct website, there's links there. I mean, I've reached out to many organizations and things, and I'm just, trying to pick up the slack.
In our helpful links and resources on that page, there's one specifically about evictions and housing.
Okay.
And in our chat box for the session today, we've put up the links. You can also just follow it through that way.
Okay. Thank you so much.
Absolutely, Ms. Joselyn. Good luck to you and your family. Today, the judgment will be, and let me give you all the final numbers. The judgment will be for the plaintiff for $3,018 plus cost of court. On appeal, it's just October, November, so I put the appeal bond as 1 month of rent. It'll be $1,811. All right.
Thank you, Your Honor.
Good luck to both of you. All parties are excused. Thank you. 25-1568.
Your Honor. Catherine Turner here on behalf of the plaintiff.
Sorry, Ms. Turner. I get it. You're announcing. Sorry, I thought it was a question coming in. Okay. 25-1568. Ms. Turner is here on behalf of Plaintiff Stephen Guzo.
Yes, Your Honor.
Aubrey Franklin and other occupants. All right. Do I have someone here? So Ms. Turner has checked in on behalf of the plaintiff, Mr. Guzo. Do I have someone on behalf of Aubrey Franklin?
I'm here, Your Honor.
Good morning, Ms.
Aubrey
Franklin. Thank you. And then are there anyone here as an occupant?
My daughter's away at school.
Okay, that's fine. Yeah. All right, Ms. Turner, tell me why this eviction sought.
Sure, Your Honor. This is based on non-payment of rent, and then it has also come to our attention that there is a violation of the lease. Specifically, paragraph 9, there is an unauthorized animal living on the premises. The lease was signed on June 17th, 2025, and I would like to tell the court in all, so that the court is aware that the lease was drafted by Ms. Franklin, as she is a licensed realtor here in the state of Texas. The monthly rent is $2,800 per month. It has not been paid for September, October, or November. A 1-day notice to vacate was posted to the inside of the main door on October 30th, 2025, and it was also sent via first class mail the same day. And the 1 day is permitted by section 27B of the lease. There is a military affidavit on file with the court. We are seeking possession, back rent in a total amount of $7,466, which is the full amount of rent for September, the full amount of rent for October, and $1,866, which is the prorated amount for November. We are also seeking attorney fees and costs in a total amount of $3,643.02, which would be $3,500 in attorney fees at $350 an hour for 10 hours of my work on this matter, and $143.02 in court costs.
Okay, so it's really $3,500 for your attorney's fees.
Yes, Your Honor.
Okay. Good morning, Ms. Franklin.
Good morning.
Ms. Turner's here representing the landlord, Mr. Guzo. And she said this case is originally filed as a non-payment, then she said there's another lease violation, but let's just focus on the non-payment for now.
Okay.
She said that under the lease, the monthly rent is $2,800. Is that correct?
Yes, ma'am.
Okay. And Ms. Turner, there's no subsidy, or is there a subsidy?
No subsidy, and this is not a CARES Act property.
Okay. I assumed that with the 1 day. All right, then. Ms. Franklin, she says that with the $2,800, that rent hasn't been paid for September, October, and now November. Is that also correct?
That's correct.
All right. Well, with that information, Ms. Franklin, well, landlord meets their burden of proof on one of these cases, but can I answer any questions? Any information you want to share with me?
No, I'm not familiar. What is the military? There was something with reference to military.
That's a standard question that I ask. If you had not been present today, whenever a defendant is not here, the plaintiff must prove to me or swear or affirm that to their best knowledge in checking, the defendant is not currently deployed in the military. And this actually comes up. You're here, so we know that you're not. Okay. But if you had not been here, it is a requirement of the law that they say, I'm not trying to evict someone who's currently out deployed in the military.
Right. Okay. Understood.
Oh, that's a great question, because it is something I always ask, and I don't know that people ever know why we ask it, but that's the reason. It's called the Service Member Civil Relief Act, the SCRA. And so that is a thing, and yeah, it's a necessary form. All right, well, that's a good question. All right, then today will be a judgment for the plaintiff, the 7466, which is September, October, prorated for November. We would award the attorney's fees of $3,500, and we would put plus court costs, because that's always awarded. For either party to appeal, I would put the appeal bond at $5,600, which is twice the monthly rent, since rent is due from September. All right.
Okay. And just to be clear, so I would have to pay the court $5,600.
That's the appeal bond. If you were able to and can afford it, then yes, you would pay the appeal bond. There's some other options available to you. And then in addition to that, if you appeal and you want to stay, you have to pay the rent of $2,800 as well. You can't appeal and not stay. I've seen all versions of that. Okay.
Okay. And it's still 5 days after today, correct?
That's correct. And all right. Again, with a little caveat about if there's a holiday. So that's what we say, call an attorney or legal aid, and they can actually calculate it and say, this is the date. As the judge, I'm only allowed to give you the number.
It makes perfectly good sense. Okay. Thank you so much for your time.
Thank you all very much. That all parties are excused. Ms. Turner, is this your only matter today?
This is my only matter today.
Okay. Thank you both.
Have a good Thanksgiving.
Have a nice day, or have a better day. Well, sometimes I'm a little too friendly, and I realize that. No one's happy to be at this topic. All right. Thank y'all.
Thank you.
The next matter then is 25-1572. That's Sierra Vista versus Megan McDonald and others. Who do I have for Sierra Vista? I see I see you're trying to unmute. Good morning.
Good morning. My name is Adriana. I'm here on behalf of Sierra Vista.
Good morning, Miss Adriana. What's your last name?
Vallejo. V as in Victor. Allejo.
Okay, Vallejo. Good morning, Miss Vallejo. Do I have someone here on behalf of Megan McDonald?
Yes, Judge, I'm here.
Good morning, Miss McDonald. Thank you for being here as well. All right, Miss Vallejo, tell me why this eviction sought. We lose her?
Ah, no.
That's okay. If you don't have video, we gotta be able
Okay.
to.
So sorry. So this is a non-payment of rent case. The rent has not been paid since September. Rent was not paid in October, and the prorated for November is $732.67. There was a small.
Ms. Viejo, how much is the monthly rent?
The monthly rent is $10.99.
Is there any subsidy directly to the landlord on that?
No.
Okay. And so it's September, October, and then you would prorate for November?
Yes, and she had a small credit of some cents in September, and so for September we're charging $1,098.48.
Okay. Was this a CARES property, or is this a CARES property?
It is, and so I gave a 10-day notice to cure on on September 4th. I gave a 30-day notice to vacate on September 16th, and a 3-day notice to vacate on October 22nd.
Okay. Good morning, Ms. McDonald.
Good morning, Judge.
Thank you for being here. Ms. Vallejo is with the landlord, and she says this case is one about non-payment. So as with many of our cases, it's a financial situation. My first question is just if the monthly rent is accurate. Is it $1,099?
Yes, it is.
Okay. And she said that you had a small credit towards September, but otherwise September, October, November have been unpaid. Is that correct?
It is.
All right. Well, Ms. McDonald, with that information, as I've said to some others today, the landlord meets their burden on a case like this. Certainly, if you have any questions, I always want to answer those, or if there's any information that we can provide you, we would like to be able to do that for you. For the month of November. Oh, go ahead, Ms. McDonald, I'm sorry.
I have, it's such a crappy situation. Whenever I had to move from another Foundations for Communities property, we were given a relocation check. Not only did it take forever to get this check, which I understand, it gets backed up. Everybody had to move out of the complex. But once I got said check, not even 2 days later, 3 days later, it bounced out of my account and put me negative $300. I'm a full-time single mom. I do have a full-time job. I don't get extra help. I'm not on food stamps. I don't get WIC anymore. My son's father does not help me. I do have some checks and some money orders at home. It's just not quite the full amount of what I need. So I do have money for September and October. It might not be all of the late fees, but once I get this all figured out, I can talk to my work. I work for Subs, and they would be willing to help me with the rest of what I need. And then for the month of December, at midnight on the 1st, I need to call up to the Prosper Center and see if I can get December covered.
All right. Well,
and then after that,
I wasn't trying to cut you off, Ms. McDonald.
I'm gonna go to community court. A friend told me. No, it's okay. A friend told me about community court down in downtown Austin and said that they had programs. And since I have a child under 5 or 6, then I would definitely qualify and get some extra, very much needed help.
Do check with that court. I am familiar with the community court. They do have quite a few resources there because of the type of work that they do and their population. Ms. McDonald, I wish you very best of luck. I understand you're facing lots
They've
of
been nothing but
challenges.
amazingly sweet and nice.
Let me give you the outcome for the court because this is as much as I can do. And then certainly I want to highlight you have at least 5 days to try to make some things happen. The landlord, that's the legal deadline, right? The landlord can work with you after that, but legally they do not have to. Within the next 5 days, you do have some options, including your right to an appeal. Okay. So let me give you the numbers because if you're going to contact any of those providers for legal aid services, letting them know the exact information may get you a little bit further along or faster, certainly. So today for the judge.
Let me grab a pen.
Absolutely. We will also email this to you
Sorry,
today,
I'm ready.
Donald. No, you're just fine. All right. So for today's cost, for today's case, Sierra Vista versus Miss McDonald, the monthly rent we found to be $1,099. With credit toward the September of $1, it makes it $10.98 from September, all of October at $10.99. And then for November, I calculated $732.68. That's 20 days at the prorated amount. So I took the number, divided it by 30, and then multiplied by 20. Total judgment to the plaintiff is $29.29. $2,929, so $29.29. For either party to appeal, I would double the rent and make it $21.98. Ms. McDonald, Ms. Viejo, we will send you both copies of the order along with information about your rights to appeal. For example, Ms. Viejo, if you wanted to get the entire month, I've had people who want to appeal me about that, right? So there are times that the plaintiff appeals. Not as common, but it does happen. All right, Ms. McDonald, very, very best of luck to you. I like where you work. They do make a really good sandwich. And it's also very nutritious and healthy. That's not a plug for anyone. I'll just say that I've counted them all. Okay. All right.
You like thunderclouds.
Our office has done the turkey trot several years in a row. Now we sign up for the 1 mile and we definitely walk it, but that's still exercise.
My kids doing the kids run, and I'll be slinging t-shirts before that. So
okay. Well, very best
I'll
of
be
luck
there.
to everyone. All parties are excused. Okay. Thank you very much, everyone.
Thank you, Judge.
Melinda Rice versus Leonard Hardgrow. Do I have someone here on behalf of Melinda Rice?
And I was trying to see if someone was checking in for that one because I didn't get a plaintiff for that one. I did get the defendant. So,
all right. Mr. Hardgrow, thank you for being with us today. We've not had anyone at this point check in on behalf of the plaintiff. Melinda Rice, we are now a full hour into the docket. We've been checking parties in for that time and allowing late arrivals. Mr. Hardgrow, you don't have to make any response, but I'll just let you know that actually, Mr. Hardgrow, can you hear me?
Yes, I can.
Okay, you don't have to do anything other than just, I want to make sure you're here with me to hear that. Because the plaintiff hasn't arrived, the court would do something called dismiss for want of prosecution, which just means if the plaintiff isn't here, the court doesn't move forward with anything. We just dismiss the case. Now, Mr. Hardgrow, if there's been a medical emergency, some real horrible reason or an interference, let's say something happened. If we learn about that in the next, say, 24 hours, we may reset the case and give you notice again, and we would do this hearing a different day. If we don't ever hear from the plaintiff can also just redo this if they wish to still try to move eviction. If you've moved, it may be that nothing ever happens, but as of today, the case is dismissed and you are free to leave.
Your Honor,
you don't have to do anything though.
Okay, I would say that Melinda Rice told me that she would not be attending today. She and I settled this earlier. I filed an answer to her suit.
Okay. Well, Mr. Hardgrow, thank you for coming. We are going to dismiss the case.
Okay, great.
Thank you. You're all excused. Have a good day, sir.
Well, ma'am.
Your Honor, and I did want to mention, even though this case is being dismissed, defendant did file a dismissal, and we were going to hear the dismissal as well. So,
well, we're going to grant it.
Okay. Well, I'm just wondering if this type of dismissal changes the plaintiff rights to appeal, or I also am wondering if the writ of possession is
nothing can happen, Mr. Hardgrow. The case is not going to be dismissed on your motion. It's being dismissed because the plaintiff did not appear to the hearing. So we don't even need to entertain it. It's going to be dismissed. The plaintiff can absolutely refile. They can't appeal this type of dismissal. They can either refile or notify me that I set it aside in error. They had they had a medical emergency that prevented them from coming. Something happened in the family. I don't know. We've seen some examples, but you can't appeal a dismiss for want of prosecution. They can either tell me there was a reason I should put it back on the docket in a very quick amount of time or start the process over.
That was the answer to the question I had. Thank you very much.
You got it. Happy to do it. That's a weird distinction, but that's the reason for it.
Great.
All right, Mr. Hardgrow, thank you. You're all excused. Have a nice day.
Thank you.
And then Mershey, it's a DWAP. All right, then we will be with cause 25-1575, Old San Antonio Road, doing business as VIATX versus Destiny Alexander and other occupants. On behalf of VIATX.
Nationwide.
Do we have someone for the defendant or anyone on their behalf for Destiny Alexander?
Yes, I'm here.
Good morning, Ms. Alexander. Thank you for being with us. All right, Ms. Carcos, tell me about this eviction. What is the cause?
This is failure to pay rent. Rent is $2,179 a month. She owes October and the prorate of November for a total of $3,631 in back rent through today. A 3-day notice to vacate was mailed on October 20th. This is not a CARES Act property. There's no government subsidies, and we're seeking back rent, court cost, and possession.
All right. Good morning, Miss Alexander. Ms. Carcos has said that this case is a financial situation. Is it correct that the monthly rent is $2,179?
Yes,
All right. And then she said rent hasn't been paid for October and November. Is that also correct?
that is correct.
Okay. Ms. Alexander, I definitely understand. It is often a situation of an impossibility, right? And not a I'm not paying. It's I don't have the ability. But Ms. Alexander, with the information that you've given me and from Ms. Carcos, that would be a judgment for the landlord today. Can I answer any questions for you or give you any information?
Yes, so for October and November, there was like a promo for like half of it off. So it's supposed to be 1,200 each.
Is that a contingency upon you paying in full?
I'm not sure.
It is, Your Honor. So they did give her a concession, and then because she had an NSF, she didn't qualify for the concession.
Ms. Alexander, that's typically what I see in these, and I can take a look at the lease. It's an incentive. They'll give you half off if you pay the other half, but it sounds like the other half, that check did not go through, and if it was insufficient, you don't get then the credit for the other half. You still owe, you now owe the full amount.
Okay.
All right. Are there other questions? Because that's a good one, and we've seen that in common.
And then how much are the filing fees?
Typically, it's about $136, $164. Sometimes I confuse these together. I've got it here. Court cost. Pull this one up. Looks like for this one, it was $139.
Okay, so everything's right on the ledger?
I'm only concerned about whether October or November are paid. So the rest of the ledger is between y'all, right? The court is, for the purposes of eviction, it's did you pay rent pursuant to the lease on time? Right. Ms. Alexander, today the judgment is only for the unpaid rent and it's only being paid, the judgment is only being granted through today. So I'm not awarding the full month of November, even though you may end up being there the rest of the month.
Okay, and what about the late fees?
Those do not come as part of the judgment. That's a great question, Ms. Alexander. In court, the law says the landlord is here for 2 reasons. They need possession, and if rent remains unpaid, they can ask for the basic amount of the rent. They are not allowed to ask me to award late fees, utility fees, cleaning fees, pet fees, parking fees, any of the other stuff that you might be charged by your landlord. However, that is still a legal obligation to pay it. It's just not awarded in the eviction. So it is not outside the realm of legal possibility for your landlord to send you a bill that says you still owe me for all of those other things and then sue you for all of that other stuff. Whether they want to or they do, I talk to your landlord, right? But legally, the judgment or eviction is just for possession. And today, the amount of rent I calculated is $36.31 for the month of October, and a prorated amount. I would award $36.31 plus the cost of court, and that would be the judgment of the court today. You might get a bill from your landlord that is a much different number because it does include all the other things you promised to pay under the lease.
Okay.
I know
And
that's
for
a weird one. Oh, I'm sorry?
For the appeal bond, how much would that be?
For the appeal bond on this one, it would be equal to 1 month of rent, $21.79. And we will send you that information today with a copy of the order. We send that to the landlord as well. We'll also mail it, but email's a lot faster.
Okay.
All right. So Ms. Alexander, here's the total, the judgment and the numbers. The judgment amount is $36.31 plus cost of court. Either party can appeal. The appeal bond is equal to 1 month of rent, $21.79.
Okay, thank you.
Very good luck to you, Ms. Alexander. Thank you. Very good questions. And Ms. Carcos, if you have others, you'll stay with us. Otherwise, you're excused. Okay, thank you.
Thank you.
Right. Then our next one will be cause 25-1576. Sherry Gail Duke, Castle Park Investments versus small child occupant, Eric Unknown, Cherie Valencia, and others. Who do I have here on behalf of Duke and Castle Park?
That would be me, Your Honor, Sherry Gale Duke.
Good morning.
Good morning.
Do I have anyone here on behalf of, let's go first with Sherry Valencia. Anyone here for Sherry Valencia?
Yes, I'm present.
Good morning. And then is there anyone here representing the occupants?
No, but I also have Eric on the phone listening, and he'll.
So Eric is here, Miss Valencia is here, but no one for the occupants. All right, that's fine. Ms. Duke, tell me why this eviction sought.
Okay, so I started on the property on September the 13th. Actually, I'm sorry, September the 15th. And we actually had a visit from our corporate office, and they saw the site of what 121 looked like. And we're also trying to build a tiny home community at that point in time. They did ask me to get with the occupants to clean up their site, which they had not at first. But so what had happened is that I had to send 2 notices of violations to their properties, that they had way too much stuff. There was bedroom furniture out in the back of the RV, and all of this is facing our road, so it was affecting our business, and we were losing revenue from our tiny home community. So at that point in time, when I sent them the notices, I never heard anything from them. And when I told them I was going to send them an eviction, that's when they came into the office, Miss Cherie, and then Eric came in as well to the office and was screaming and yelling at her. And then later came back and told me that's how he speaks with her. But I don't allow that kind of talk in my office. It's not professional. And it just didn't make me feel very safe. So
if I hear you correctly, then this is about a lease violation. They have too much trash at their property.
Yes, this is the lease violation. So
okay,
but
Miss Duke, Miss Duke,
you got to tell them that we were given permission and we got.
Sir, sir, you're proving the plaintiff's case.
It's
what you just did is prove the plaintiff's case.
We'll have her turn to talk.
Miss Valencia.
Yes.
Not a good start for your side of the situation.
I apologize.
Like he literally just said he came in and started yelling, and before I could ask her a question, he yelled out.
He was unaware of the rules, but I let him know.
I find it hard to believe that anyone doesn't know they should conduct themselves with decorum in a courtroom.
He didn't hear the part where we
How
were
old
gonna.
is he?
Yes.
Is he an adult? Is he over 18?
Yes, he is.
Then he should absolutely know to behave with more decorum in a courtroom. Anyone who's seen TV knows that that's how you behave. We'll return to the plaintiff's case. Miss Duke,
yes,
is
yes,
there
Your
a
Honor.
written lease?
I was being heard.
Miss Valencia, you can actually mute yourself and avoid any further embarrassment. Miss Duke, is there a written lease?
No, there is not. What
Then
she actually had.
Matt, Miss Duke,
I'm sorry.
there's no written lease.
No.
Now, you said that you came into this sometime in September, so you are a new entry to this situation.
Yes, Your Honor.
To your knowledge, or the knowledge from the company you're representing, how long have the defendants been in possession of the unit? How long have they been tenants?
Let me look at that. They actually moved in on July 31st, 2025.
And if there's no written lease, how do I know what the terms and conditions are?
What they have is a site agreement. It just says what they're going to be paying. And they are actually parked in a platinum site. And of course, I was not here.
Miss Duke.
Yes.
You told me there's no written lease, but did you say they have a site agreement? What's a site agreement? Is that in writing?
That is in writing, and it just says what they're going to be paying.
Is it signed by the defendants?
It is signed by the defendant, but it's not signed by management previously.
What's the date that it was signed?
It was signed on actually, there is no date on here.
Does it have any terms and conditions? Because there's nothing that was submitted to the court. So I can't look at this magic document to know if it actually has any terms or conditions that they could have violated.
This was submitted to the court online.
O'Shea, do you see it? When was that
Electron.
submitted, Ms. Duke?
That was submitted on. Let me look at my paperwork. November the 5th, 2025.
I have the petition. It's just 2 pages.
That's correct, Your Honor.
Ms. Duke, is there a chance you could share your screen and show it to me? Do you have it online?
Put a note on there on 11/5 on the notes tab that it was filed without notice to vacate, military affidavit, and lease.
So nothing came in, Ms. Duke.
I'm sorry, Your Honor.
We have a note that it was filed without any additional paperwork. We just got a petition. No lease, no military affidavit, no notice to vacate, nothing.
Okay, well, this is the first time I'm actually doing it online, so I know that's not an excuse. But I know that corporate does want them to move.
Well, I get that, but you don't have a lease. All right, let me ask another question. So there's no agreement to pay rent that I'm aware of here. Under the site agreement that you're looking at that is signed but not dated, is there an amount that's supposed to be paid?
It's actually supposed to be $875 because the site they're in.
That's not what I asked, Ms. Duke. What does the agreement that you signed say?
$699.
See what I'm saying? Don't misrepresent things.
Okay.
If what you signed that's not dated and you didn't provide me proof says $699, you need to go with $699.
Okay.
Okay. Now, is she renting a site or an RV?
She has an RV in the site.
But is she renting the RV or the site or both?
The site.
The site. And is this a place for manufactured homes?
No, it is not.
What day was the notice to vacate provided?
That was issued to them on October. The first one was on October the 9th. The second one was October the 20th.
And the one on October 9, how was it delivered?
It was actually hand delivered, and then I also sent it via email.
The one that was hand delivered, what were the terms and conditions on it?
It was actually in an envelope. I knocked on the door and nobody answered.
No, but what does it say? Because you didn't send them a copy. I don't know. So what does the notice to vacate tell them?
It tells them you are hereby required to vacate the premises on 25928 Haney Flat Road, Spicewood, within 72 hours of the notice. You were served this notice on 10/9. 72 hours after the date would be 10/12/2025. If you have not vacated the property by 10/12/2025, the police will be called to escort you off the property.
All right, then how about the one on the 20th? How was that delivered?
That one was delivered on the 20th as well. Yes, Your Honor. And it stated the same thing.
How was it delivered?
It was hand delivered and then via email.
Another 72 hours?
Yes, Your Honor.
All right, do you have any evidence to support the lease violations?
We actually do, because their site was a mess. I actually have pictures.
That's what I'm asking, Ms. Duke. Can you share those photos with the court?
I did not. They were actually on my phone, so I did not share those.
Do you have a witness who can testify as to the state of the property?
Yes, my assistant manager.
Fantastic.
Jason,
Where are they?
Would you like for me to call him in?
Yes, Ms. Duke. You have to prove the case.
Okay.
All right.
Okay. We are asking him to come in.
Ms. Duke, while he's coming in, take a look at the site agreement. Other than amount for payment, is there any details or conditions on it?
It just says the site agreement, excuse me, the site agreement is made between Spicewood RV Resort, referred to as herein as the owner, and the individual referred to as herein as guest. Guest agree to all terms and conditions of the license agreement, and additionally are bonded by all site guidelines incorporated as Addendum A.
Is there an addendum A attached to it?
No, ma'am, it's not.
And that doesn't do you any good. Ms. Duke, I'm afraid that you're not meeting the burden that you need. In order to show me that she's violated a lease, there needs to be a lease and there need to be conditions on it. If what you have is simply a site agreement that, per your information, isn't signed and isn't dated and has no addendum to it, you're not going to meet the burden of a violation, because even if you came in and showed me photos of a bunch of trash, what tells me that that's not allowable under the agreement that she signed, even assuming I agreed that that thing was signed.
I
Right?
understand.
And for Mr. Eric Unknown having a very, aggressive way of handling himself, I'll grant you, that's not a great way to behave, certainly not in court, but that is not a violation of a lease if one doesn't exist.
Okay.
All right.
And Jason is coming in now, Your Honor.
I look at your petition, you only sought a violation for lease violations, nothing about unpaid rent. I take that to mean that the defendants have paid their rent in full.
No, I did not collect rent on them at all. I'm doing exactly what corporate asked me to do, and they just wanted them to leave. We do not want to even collect any money.
All right, well, unfortunately, Ms. Duke, with that information, I don't find that the landlord is meeting their burden to show a lease violation. Certainly you can appeal my decision, right? This is the example where the landlord might want to appeal.
Okay.
And you can move forward that way. You can appeal. You can start the process over by alleging a different type of lease violation or the same thing. You can do as you like. Certainly you can talk to an attorney or to corporate, and they might have a different idea about what they'd like to do. But today it's going to be a judgment for the defendant, and it's going to be for a lack of evidence. Okay.
Okay.
Certainly you both can appeal. I would put the appeal bond at
They want to
$6.99.
know
That's
what
equal to one of the site
the
amounts.
judge would like to know what their site looked like.
It was a mess. They had.
We're not taking your testimony.
Okay.
Here's the thing. When you file the eviction, it is always best to file the necessary documents, the lease, a ledger, a notice to vacate. We don't have any of those things, so I can't review them. And what I was hearing today in the testimony from Ms. Duke is that the site agreement does not have an addendum. It doesn't specify any terms and conditions. It only specifies an amount of money. Nothing in the petition. In fact, the petition explicitly states that y'all are not seeking anything for unpaid rent. So if it's just a lease violation, I don't find evidence to support that.
Okay.
Absolutely still have options. Ms. Valencia, they can still do other things. So I would encourage all parties to maybe communicate with each other about a resolution. All right. Ms. Duke, do you have any questions?
No, I do not.
All right, Ms. Valencia, do you have any questions?
Yes, actually. I would like to know where I can file a claim to countersue.
There's no counterclaim in an eviction. That's
Well, the
all
thing
I
is,
have.
ever since Miss Sherry Duke came into the office as office manager, we're an interracial couple.
Ms. Valencia, please contact legal aid if you think you have a claim against your landlord.
And I have.
There's no such thing as a counterclaim in an eviction.
Yes,
okay?
I've contacted legal aid.
Fantastic. Good luck, everyone. All parties are excused today. Thank you.
Thank you.
Thank you.
All right.